Hi, this is Kowski for AP Gov Review, and in Unit 4, Part 4, in dealing with the federal courts and the judicial branch, we're going to be looking at some of the major participants, amongst other important things that are notable in the judicial system. So let's first start off by talking about two types of cases within the judicial system. The first one being criminal law, where the government charges an individual with violating one or more specific laws. So that might be an act of trespassing, an act of murder. That, of course, would fall under the criminal law statute. Now, with civil law, that is not a charge of criminality. You have not violated a criminal law. However, you're having one person accusing another person of violating his or her right. So, as you see in this chart down below, criminal law, crime as a public wrong, you have the government acting as a prosecutor, proof beyond a reasonable doubt, which is a very high standard because you could potentially be putting somebody away in prison. So that's why you have proof beyond a reasonable doubt. Whereas within civil law, it's just a preponderance of the evidence. Just merely if the evidence, the majority of the evidence points to that person, that is enough to find that person guilty. It could be an injured person as a plaintiff. So for example, that very famous McDonald's case where scalding hot coffee was dropped on the plaintiff and she sued and she won that notorious case. So if you are injured, that falls under civil law because it would not be a crime unless it was done intentionally. And of course, McDonald's would never want to hurt a customer with scalding hot coffee. Punishment is in terms of compensation, unlike incarceration or death for criminal law. And then you see tort as a private wrong. Interestingly enough, the United States government is involved in about 2/3 of all cases brought to the federal court. That's either criminal law or that could also be civil law. A lot of them do involve civil law type matters. That's important to note. But you do see the U.S. government being either a plaintiff in the form of a prosecutor, or it could be in terms of a defendant. Many people sue the U.S. government in federal court. All right, so some of the major participants in the judicial system, and of course this is just overview should it appear on your AP Gov exam. So of course you have your plaintiff, that is the person bringing the charge, and again this would be in civil court. The defendant, that's the party being charged, that could be either in civil court or criminal court. And you have a jury, the people who are of course going to decide the outcome of the case, and you have a jury both in criminal and civil court. But what's important to note is that you have to have standing to sue. This refers to plaintiffs having a serious interest in the case, that they've sustained or likely to sustain a direct injury from the government or somebody else. So if your neighbor were to get in a car accident and be significantly injured, your other neighbor who had nothing to do with it can't sue on behalf of you. You have to be involved, directly involved in the incident. So hence, you have to have some legitimacy in terms of being able to sue that person. Another important thing to realize is that a case has to be deemed justiciable, in the idea that a case must be capable of being settled as a matter of law. So hypothetically, a citizen could not sue Congress because it isn't going to fund a social program. Again, it cannot be hypothetical. It cannot sue about funding because that is something that Congress deals with. That is a fundamental right of Congress. So that is important to know. All right, continuing on, so other participants in the judicial system, certainly of interest groups. They're going to use the courts to try to change policies, as we saw in Unit 3 on our discussion on interest groups. And oftentimes that they're going to use the judicial system as a last resort when lobbying efforts are not going to work. So a good example of this, when you see the NAACP, they were very important in bringing about the landmark case of Brown v. Board of Education. It was filed as a class action lawsuit, and what they purposely did was they sought out litigants to represent a cause that they supported, in this case, of course, ending segregation. So they're going to find a litigant who will represent their case the best, and certainly it was very successful. Other times, interest groups, if they're not directly involved, they will file what's called an Amicus Curiae brief used to influence the courts. And this was mentioned again in our interest group chapter in Unit 3. And of course, that refers to being a friend of a court. You're writing a brief used to raise additional points of view and information that may not be contained in the briefs of the formal party. So you may have nothing to do with this case. You're not involved as the plaintiff or the defendant, but you have some type of interest in the outcome of this case. So as a result, you would file an Amicus Curiae brief to bring out additional points that may not have been raised originally. So that's another way that they can influence the judicial system. Also important, attorneys. There's over 800,000 lawyers in the United States today. And of course, what really spawns a lot of lawyers is going to be another landmark case known as Gideon v. Wainwright, which essentially mandates that you have to have a public defender if you cannot afford one. Everybody is entitled to a lawyer in the criminal justice system. And you also have attorneys who are involved in the Legal Services Corporation, which provides lawyers to assist the poor as well. And really, access to quality lawyers is not equal. There are many disparities between a public defender, not saying that they can't do their job right, but oftentimes they are known to be overwhelmed with the number of cases, underpaid, so you're not necessarily attracting the best lawyers depending on where you are in the country. Also, do be aware of the Attorney General. That is the head of the Department of Justice. They're not called the Secretary of the Department of Justice, but they're called the Attorney General. But again, the same idea that they're overseeing the Department of Justice, or the DOJ. And then you also have the Solicitor General, who represents the government to the Supreme Court if the United States is sued there or is a party in one way or another. You will have the Solicitor General, who again is the head lawyer in a way of the U.S. government. So some constraints on federal courts. People think often, especially in the public, that the courts really have so much influence, and to a degree, yes, they do have a lot of influence, but there are constraints. So for example, in the adversarial system, a case must come to the court. The court cannot orchestrate a case to come up to the Supreme Court. It takes many, many different avenues and takes a very long time for a case, especially one that the Supreme Court wants to hear, to come up. So it cannot be active in saying, okay, we want you to sue this person or you to sue the government over this issue. The court has to wait for basically a case to come up for the rule of 4 to kick in. So that's important to note. As we said earlier, this cannot be a hypothetical situation. The court only rules on actual cases. It's one that can only be ruled through legal methods. So again, it has to be an actual case. And then with respect to political questions, matters that the Constitution leaves to another branch of government. So for example, which group of officials of a foreign nation should the U.S. government recognize as being legitimate? Well, the judicial branch sees that as being a role of Congress and not the judicial branch. Also, keep in mind, if Congress wanted to pass a law, but they're like, hey, will the Supreme Court, see this as constitutional? They can't do that because, again, that is a hypothetical situation. It's not an actual law. It has not come before them as a case. So it has to be a real case. It has to be one that has gone through the court system. Again, the court cannot seek out cases. It cannot be a political question either. Again, anything with recognizing a government or should a particular program be funded, that is not for the role of the Supreme Court or the federal courts. Now, in terms of accepting cases, that's important with respect to the Solicitor General, of course, is the presidential appointee and is, interestingly enough, the third-ranking office in the Department of Justice. Very important, in charge of the appellate court litigation of the federal government and some of the key functions. I don't think you're going to need to know this for the AP Gov exam, but just in case, deciding whether to appeal a case if the government loses, you're modifying, reviewing briefs presented in the Court of Appeals. Probably the most important function that you should know is representing the government before the Supreme Court, and of course submitting a brief on behalf of a litigant in a case in which the government is not directly involved. And again, that could be an Amicus Curiae brief. So sort of the process, justices receive the printed briefs of each side before the legal arguments come about, and they look at precedents. How have past Supreme Court justices ruled on this? That's very important. And as we said earlier too, they will receive Amicus Curiae briefs. That is important. For such important cases that have gone through the Supreme Court, a mere 30 minutes is given to each side. And at any time, justices can interrupt for questions. So you might have 30 minutes of great points, but you might only be able to fit in 15 or 20 minutes of that if you're lucky, because you have 9 sitting justices who could potentially be asking you questions. So it is very, very short, and you want to use that time as best as possible. So in terms of making the decisions after the case is heard, after the oral argument, as you see here, conferences are going to begin, where you just basically have an informal discussion. You're not taking a formal vote at this point, and the justices are just going to have a discussion. After you have the discussion, again, you might take an informal vote once again, and once a decision is made and you find a legal reasoning that is, of course, important in the U.S. Constitution, this has to be formally stated. And ultimately, one justice will write the majority opinion, which is a statement of legal reasoning behind a judicial decision. So content is very, very important because it's going to be setting a precedent for other federal courts and state courts as to how to decide similar issues, should that, of course, reach them. And this is very important because this is how judicial review was set up by John Marshall, basically the hallmark Chief Justice who made the court the way that it is today. Because remember, the Supreme Court basically gave themselves the power of judicial review. The dissenting opinion would be if you're voting against the majority and you're explaining why. And there's also something called a concurring opinion, which you agree with the decision, but you support it for other legal reasons, not one that's going to be stated in the majority opinion. Also important to note is that when you have cases coming to the court in your ruling, there's a concept known as stare decisis, in which you're letting the previous decision stand unchanged. So basically, you're deferring to the precedent, how similar past cases were decided. Supreme Court justices do not like to overturn or overrule cases. It can happen, but it is rare. Precedents can also be further clarified or narrowed. That's important to note. And court justices also do, to some extent, look at original intent. The idea that the Constitution should be viewed according to the original intent of the framers. How would the Founding Fathers really have viewed this particular issue? And that can be very difficult because we're in many, many different times. We have more technology. We just are in a very different society. So viewing it through this lens of original intent can be very difficult. But you do have justices. For example, the former Anthony Scalia was a very big proponent of original intent. Ultimately, when voting, you need a minimum of 5 votes for a decision. If you have only 8 justices because the vacancy has not been filled yet, you get a 4-4 tie, then you do not have a majority, and the ruling of the lower court, which would be in the Court of Appeals most likely, or the state Supreme Court, would basically stand. So the lower court's ruling would stand. Okay, so let's end with a review question. Take a moment to look through the choices here. So the doctrine of original intent holds that. And if you said choice B, the meaning of the Constitution, depends on the intention of the framers, you would be correct.